equal rights for all, everywhere. Say what you think, what you think, what you think, what you think about justice. What you know, what you know, what you know, what you know about love. Why all the segregation, all our but foundation. Oh, let us unite as one. Let us unite as one. Tell me what you know about love. Tell me what you know about hate that keeps us separated. Tell me what you think about equal rights for all in every way. Say what you think, what you think, what you think, what you think about justice. What you know, what you know, what you know, what you know about love. Why all the segregation? We all are but one nation. Oh, let us unite as one. Let us unite as one. Oh, love. So many can testify. Love, oh, love. But you still can't satisfy. You keep on praying. You wish that day would come when there'll be equal rights and justice for every man.
All right, good morning once again. Good morning to all of our viewers, and good morning to all of our listeners. And good morning to Inspector in the studio here with me. How are you doing today, sir?
Yeah, I'm fine, and always happy to be here on this program, Policing with You.
By the way, it's Inspector Griot, pardon me. Inspector Griot is in the studio with us this morning. So, what are we going to be looking at today, sir?
Today, firstly, I want to big up all the persons out there in radio land, TV land, and the different social media houses, and also the different mediums they are using. I want to big up all the people in the diaspora as well who listen to this program weekly, and I want to thank them for the time, because they could have been doing something else, but yet they choose to listen to ZIZ and Policing with You. So I want to thank you.
Indeed, indeed. So the last...
And as I said,
yes, sorry, go ahead.
Last time I was here, I looked at offenses against the property. And this morning, I'll be looking at offenses against the person.
All right, so let's start with a few questions before we open the lines and hear from our listeners. And we're going to take a break at 9:30 to do so. So my first question for you this morning, Inspector, what is the meaning of an assault let me rephrase that. Let me put it this way. What is the meaning of an assault, and when can someone be charged with such offense?
Assault, according to the Act, it defines assault as any act by which a person recklessly or intentionally causes another to apprehend immediate or personal violence. To give an example so that persons out there can understand what assault is. For example, say Billy is standing outside the Chinese supermarket at Spot Street, okay? And Ibo ride up on a bicycle. And when passing Billy, Ibo then take a gun and point it at Billy. But he didn't say anything to Billy. he just continue peddling. That is an assault, because Billy, at the time when Ibo pointed the gun, apprehended immediate personal violence or fear from Ibo pointing the gun at him. So that will be an assault. The act in relation to assault is under, as I said, under the Small Charges Act, and it is section 13(1). And what he says, that any person who assault or beat any other person shall be liable of a fine not exceeding $3,500 or an imprisonment for a term not exceeding 2 months. But when we look at the second part of the question that's deal with aggravated assault, section 2 of the Act speaks to that, and it said that any person who, in the opinion of the magistrate, is guilty of aggravated assault, and it goes on to talk about on any male child who does not, in the opinion of the magistrate, exceed 14 years or be upon a female, any female, and it states that shall be liable to a fine not exceeding $5,050 or to imprisonment of a term not exceeding 6 months. However, the police officer has a responsibility in dealing with these matters, and I'm going to use the word meticulous, because they have to meticulously gather all the supporting evidence and bring it before the magistrate, because it's the magistrate is the one who will determine aggravated assault. Police do not charge for aggravated assault. Police will charge for assault or battery. And once they take you before the court, by presenting the other evidence in court, then is when the magistrate will determine and deem that person guilty of aggravated assault.
So you have two assaults there. One is aggravated, and one is
assault.
What we know just
assault.
Regular assault.
Yes, when the person apprehend immediate fear or violence from someone.
But with that aspect, let me ask this: how can you prove that my presence is threatening you?
No. You have to do something for me to apprehend immediate personal violence.
Well, how can you prove that in court, though?
The person will come to court and they will give the evidence. Like the example I give you, that Ibo did ride up on the bike. And then we'll also check for cameras footage to help support
well,
our
okay,
case
now you're talking, because it's your word against my word. Right.
And also, if anybody else was there, the police would then record statement from eyewitnesses who will come and support.
Okay, that makes sense now. That makes sense, because at first...
And that is why I said the officer should meticulously, gather all the supporting evidence and present it before the magistrate, for the magistrate to make that determination.
Okay, that makes sense. All right, so let's move on. I think that point is clear. And if not, when we do open the lines, you can always call back in, or call in, I should say, and seek clarification if it's not clear for you. What is meant by larceny from the person, and how is it differs from robbery?
That's number 3. Okay. Larceny from the person. When I was here last time, I spoke about larceny. And I told the audience that larceny means stealing. Okay, and according to the Act, when it relates to larceny from the person, the Act tells us that a person who steals any chattel, money, or valuable security from a person of another commits a felony, and on conviction is liable to imprisonment with hard labor for a term not exceeding 7 years. Just to give an example of this. For example, okay, Mike is walking down 4th Street. Or say Susan is walking down 4th Street. And she got a very expensive Gucci bag. Okay, and Bill runs up behind her and snatches the bag and run away. That is a clear case of larceny from the person. But with respect to robbery is different, because say Susan is lying in 4th Street, and Frank walk up to Susan with a gun in his hand, and he points the gun and demand a purse. A purse having, say, $1,300. Takes a purse and goes with the purse. Now, that is larceny. I mean, that is robbery. You see, the difference is that in the case of larceny from the person, the person who got the bag snatched, okay, didn't apprehend any kind of personal violence or fear during the commission of the crime, as opposed to robbery, where the person apprehend fear or was assaulted. You know, and there are various degrees of robbery.
Wow. Okay.
Right.
No.
Go ahead. Right. And when we look at section 31A of robbery, where somebody comes and they decide, well, boy, give me your money, otherwise I punch you in the mouth, punch you in the face, you know, and you give them your money. That is under section 1A. Then they also have robbery with violence, where a person will come and beat you up and takes away your money. And they also an assault with intent to rob, whereby somebody may come with a gun and stick you up, but it's intercepted. Okay? But the investigator must gather all the evidence from the complainant in order to determine the section of charge to charge the accused of.
So in one instance, you can have more than one charges then?
Yes, no, it depends on, right, it depends on what occurred. It depends on what happened.
Yeah, go ahead.
It depends on...
wait, sorry for Inspector Guillo reaction there. We are now joined by Sergeant Richards. Yes, well, go ahead.
Right,
Yeah.
It depends on the evidence, you know, and I come back again, meticulously, the officers need to gather the supporting evidence in order to substantiate the charge in relation to which section to charge the accused.
So the officer should be fair with the law. That's what you're saying.
Correct.
My final question before we take a break, and then we'll join Sergeant Richards, hear from him before we open the lines. With that violence robbery you made mention of, before that person was wounded in the robbery, what constitutes a wound? Will that be something you look at differently?
Yes. Yes. Yes, yes. We look at wounding differently, because in terms of Section 55 of the Small Charges Act, it tells us that the skin of the person must be break. That means the continuity of the breaking of the skin, as opposed to somebody who get bruised. You know, will determine the charge.
Okay.
Yeah.
Okay. We're going to take a break. It's 9:30 in the studio. The morning show is coming to you compliments National Bank, The Cable, Domino's, Smart Electronics, Courts, and Beacon Insurance. We'll be back right after these messages.
Plus, the cable gave to me free internet connectivity with lots of prizes and surprises for my loyalty, proving the cable really cares for me. There's HBO Plus streaming on Ultra TV and free extreme internet upgrade for all teachers in this land. So get your cable plan and bundle packages for the family. The cable gave me a platinum card that's interest-free with online shopping capability and money transfer options with no global restrictions and no monthly fee. The cable is giving back to you and me. The cable is giving back to you and me. Every boundary that we go be cheering.
Willful Skillful Sports Club presents the Luther Kelly Over 35 Cricket Tournament, October 23rd and 24th at the Edgar Gilbert Sporting Complex, Molyneux. 2 teams from St. Kitts, 2 teams from Nevis will do battle. The action kicks off from 9 a.m. sharp with 3 games daily. Musical entertainment and a wealth stockpile will be on hand. Who will win the title? Team A, 35 plus out of Nevis. Will it be the St. Kitts Travelers or Team B, 35 plus out of Queen City, Nevis? Or will it be the ex-nationals out of St. Kitts? All COVID-19 protocols must be observed. So remember, October 23rd and 24th, Edgar Gilbert Sporting Complex, the 2021 Willful Skillful Sports Club Luther Kelly Over 35 Cricket Tournament. Cricket, lovely cricket. Don't you miss it.
It's a cricket jubilee, cause it's a West Indian team.
Okay, welcome back. As I indicated before we went to the break, we're now joined by Sergeant Richards. Good morning to you, sir.
Good morning, GQ, and good morning to our listeners out there in Radio Land, both at home and in the diaspora, and those watching and listening via the internet. My apologies for my tardiness this morning. I had an emergency, but I realized you and the inspector so ably continued the show without me, so that is fine. I have no difficulty.
I have your back.
Always.
And I know you're a stickler for being early. So
yes, I'm always.
I gave you the benefit of the doubt. Yes. So as we continue.
Before the break, I realized we were discussing offences, and the cusp of today's show is discussing offences. I know Inspector Gray would have been here on a previous occasion discussing property crimes, so to speak. Today we are more or less discussing offences against the person, for which we have an entire act, the Offences Against the Person Act. So I know we were discussing wounding, but before we get into that, GQ, Inspector, tell us about threatening language and what would constitute threatening language.
That's a good question, because to constitute a threat, the police must have established that there was a threat made. Okay? And secondly, that the threat to whom was made to, that person must apprehend, feel, for it to become a threat. The Act, according to Section 9A of the Small Charges Act, it tells us, and I quote, any person who make use of any abusive, blasphemous, indecent, insulting, profane, or threatening language. So all of those other offenses fall under the same section of the Small Charges Act. And it continues, in any public place, in any place to the annoyance of the public, or tending a breach of the peace. And it continues by telling us that they shall be liable to a fine not exceeding $3,500 or to imprisonment of a term not exceeding 1 month. And a good example will be, okay, for somebody walking through, say, Meadows Alley or Cathy Alley, and as they walk through the alley, Jack sees them come in, and when the person pass, Jack said, if you only come back through here, you know, I will kill you, or I will beat you up. And then that person go to the station and makes the report. You know, and I call this a threat to the future. Because the use of if or any conjunction will amount to a condition.
Conditional threat.
Not
Correct.
a threat.
Correct.
Not a threat. You know, but the police still have a responsibility to record that person complaint and go and inform that person who made that threat, which is not really a threat, you know, to that person. You know, and still warn them.
Yep.
And still warn them. And there's a case law which support this. It's Tuberville and Savage in 1669. And it is a famous English decision. And what the court had stated back then, that he held that the conditional threatening statement without an imminent threat to harm does not constitute the assault or the threat. Yeah.
So, Inspector, two things stood out to me when you read the legislation, though. One, you indicated that the person to whom the threat was made must apprehend fear. So, in other words, if you're saying that if that is said to me and I am not fearful, then it does not constitute.
No, it does not constitute a threat. It does not constitute a threat.
Secondly, you made mention of those offences taking place in a public place. So, whether or not there is a virtual complainant, as we use in police nomenclature, so long as these actions are committed in a public place or in a public space, they are offences.
There are offences.
Just so that the
Correct.
public is clear on that. So, yes, before the break, you were discussing wounding. And as what I realized GQ asked a very a legal question. What constitutes a wound?
Yeah, and I said earlier that there has to be a break in the skin. The continuity of the skin must shows that breaking, not just somebody push you down and you get, as we could say, bruise up and you come to the station. You know, that will be a different offense. That will be battery and not wounding.
So okay, so you're saying if GQ and I have an altercation and GQ lashes me with, say, an object and my arm is broken, I haven't got, there's no break in the skin, that's not considered a wound?
No. That's a whole different offense.
That's a different offense?
Yes.
Okay. And that offense would constitute what, Inspector?
It will be inflicting grievous bodily harm. You know, and just but when we look at wounding, okay, it tells us that any person wounding any other person shall, if in the opinion of the magistrate, shows wounding is not of a serious nature, can be liable to an imprisonment for a term not exceeding 1 year. And he goes on to say that provided that the magistrate may, in his or her discretion, abstain from trying the case and may commit the offender for trial at an indictable offense. So now, what the law is saying that if the magistrate abstain from trying that matter, then it goes up to the High Court, and now the offense will be unlawful wounding.
Okay. What I'm going to do now, all right, gentlemen, I'll ask you guys to put on your headphone, and we're going to open the lines. Let's see if the public is clear with your explanations this morning, or maybe they might want to clear up something or have another question for you. Earlier, I was asking a question about violence, violence. We call it violence robbery, violent robbery, I should say.
Robbery includes violence.
Right.
Robbery, because you have robbery, and then you have robbery that includes violence.
Well,
Right?
no, you have
Robbery with violence.
You have robbery. Robbery is the taking from a person by force and putting them in fear. Yes? And then you have what we consider to be larceny from the person. Okay, so you steal from a person, that excludes violence. Robbery includes violence.
Right.
Once there is violence and putting the person in fear, then it becomes robbery.
Okay.
But I was telling you earlier that there are various degrees of robbery.
Right. No, right.
And according to the different sections.
Correct.
Because that is why I asked about the wounding.
Yes.
Because if X, I can call the names, if X commit a robbery, which
You can use me.
commits a robbery with violence, and the person got wounded, it will be multiple charges in that scenario.
Correct.
Okay. So then it would go from a charge that might have been maybe 6 months to a charge that 6 months plus another.
Correct.
The different sections will determine in
Okay.
terms of the penalty.
Right. But the individual.
The judge will administer.
I understand what you're saying.
Right,
I understand
to
what
the
you're saying.
accused.
I understand what you're saying. Because sometimes you hear about cases and you say, but the man, it's just robbery he committed, but then you hear he in prison now for maybe 4 years.
Yes.
And then when you talk to somebody and we got our way of putting our story. You just say it's just the robbery. You ain't talk about the wounding and whatnot happened during the robbery.
Well, you see, GQ, and if Inspector allow me to shed just a little bit of light.
Please
on that.
do, please do.
There may be an individual charged for, let's say for argument's sake, robbery. Yes? And then they are charged for other subsequent matters. However, the robbery is the more serious charge.
Okay.
The court has the discretion, one, to sentence you on the robbery and give what we call a reprimand and, a caution on the others, or not record a sentence for the others. Or it also has the option, if you are charged for several offenses, to sentence you on each offense. So you may have a case where Trevor Richards would have committed a robbery. Yes, I'll use me. Would have committed a robbery. Within that robbery, I may have inflicted grievous bodily harm and all of these things. So then I would have received maybe, let's say, 4 years for the robbery, 2 years for the grievous bodily harm, and maybe a year for the other subsequent offenses. So you find that's 4 and 2, that's 6, and 1, 7. Now these sentences can either run concurrently, which means that I would only do 4 years, which is the maximum sentence, because the others would run simultaneously, or they can run consecutively, where after I finish the 4 years, then I have to do the 2 years, then I have to do the 1 year.
All right.
Most judicial officers sentence you to concurrent sentences.
Okay.
It is only in extreme circumstances you find persons would have consecutive sentences.
Okay.
So usually what is reported is that he get 4 years for the robbery. But in actuality, it was 4 years for the robbery, 2 years for the grievous bodily harm, and the 1 year for the other offense.
Right.
But the sentences run concurrently.
Okay.
So you only really ever serve the 4 years.
Okay.
And just to add, which I stated earlier, that there are degrees of robbery.
Correct.
And we can look at the sections, because there is a section, there's robbery with violence, and that you carry a stiffer penalty, and it will cover, so we don't have to give the additional charges, because that will cover everything. And the police officers who are investigating the matter need to make sure that they collect all the evidence to present before the court.
Okay. All right. Sergeant, I'll let you continue.
So back to wounding. So we discussed wounding, and you indicated inflicting grievous bodily harm. So tell us some of the differences between the two, Inspector.
Okay. When we look at wounding, under the act itself, for example, wounding with intent and grievous bodily harm is under the same section of the act, and inflicting bodily harm Now, that is a different section. That is section 19. So, both wounding with intent and causing grievous bodily harm is section 17. Okay, and I'm going to read what the Act states. According to section 17, it tells us that any person who unlawfully and maliciously by any means wound or cause any grievous bodily harm to any person or shoot at any person. So now you also bring in that if you shoot at someone, right, you can be charged under the same section. Or by drawing a trigger or in any other manner attempt to discharge any kind of loaded arms at any person with intent in any of the cases aforesaid to maim. Now these are the types of wound one can get.
Maim.
To maim, right, to disfigure or to disable any person or to do some other grievous bodily harm to any person or with intent to resist or prevent a lawful apprehension or detainer of any person commits a felony, and on conviction can be liable to imprisonment for a term not exceeding 20 years with or without labor. And then when we look at section 19 now, because section 19 deals with the inflicting injuries with or without a weapon. And it tells us that any person who unlawfully and maliciously wounds or inflict any grievous bodily harm upon any other person, either with or without a weapon or instrument, commits a misdemeanor, and on conviction shall be liable to imprisonment for a term not exceeding 7 years with or without hard labor. So when we look at the different offenses now, for example, say Paul approached Phil, okay, and take out his knife and stabbed him 3 times. The ambulance come, takes Phil to the hospital. He has emergency surgery, and he spent 3 to 4 days on surgical ward. That is a clear case of wounding with intent, because he used a knife and he stabbed him. And we have to look at the seriousness of the wounds he received.
Okay.
With causing grievous bodily harm, say Betty and her boyfriend arguing at home. Apparently her boyfriend went to her phone and she got upset, she got mad, and an argument came about. And then the boyfriend reacted and said, "Man, is I by the phone? I could go to the phone." She get mad, he's standing in the kitchen. She goes to the kitchen and she slapped him across the face. Now, he fall backwards on the stove. There's a pot of hot water and he spill all over him. You know, and now he's rushed to the hospital and is diagnosed with 3rd-degree burns all over his body. And that will highlight the offense of causing grievous bodily harm, because her action caused him to get those burns.
Right. Even though he wasn't directly, indirectly.
Right. Correct.
Okay.
Correct. And now when we look at inflicting grievous bodily harm now, I'm going to look at the same scenario, but we're going to just change it up a bit.
He ain't falling in the hot water this time.
No.
He tried the hot water on him.
They're arguing over the same phone story. Okay? Now she comes in the kitchen and she swing to slap him, and he moves. You know, and she becomes off balance. So he pushes her and she fell to the floor. He then grabbed a broom which was close to the fridge and started to beat her with it. And she got broken bones. Now the boyfriend now will be charged with inflicting grievous bodily harm. You know, and I hope those examples, those scenarios will be, they are very clear. So persons can differentiate between the 3 serious offenses.
One is causing, one is inflicting.
Yes.
Let's take our first call for this morning. Good morning.
Good morning, GQ.
Yes, morning, Jamdong.
And good morning, Edwards and me other partner there.
Guyo and Sergeant.
Guyo.
Richard, sorry.
Richard. That's
Good morning.
That's-
Good morning.
that's the big man at the court end.
Yes.
Mr. Richard,
Yes, Jamdong. Good
last
morning.
night in the focus on a young lady from East Bastille. She come to me and was telling me about a young Spanish boy moving like a female around Bastille. Usually at night down in the port area, troubling little boys and these mad people. I saw him a couple times, and I think you all need to go and ask him a question and get to know his status, because we don't know what he's carrying. All kind of thing in the world today. And interfering with little boys like that is a big thing. It Hanley and Meredith and Jefferson them. These people either feel much more comfortable going to Hanley and Meredith and them and explaining these things rather than coming in this focus and talking to certain people. I think you all should check it out, because that young man to come up on the ASP Hanley, we're calling there, from East Bastille, the inspector. The inspector there on the show.
Yeah.
Inspector
Inspector
Guyo.
Guyo.
Yes.
He knows about these things and what will happen. The lady told me she went to immigration, and immigration said that the report got to make. Well, I'm making a report. I go and talk to that young man, because he a man in vehicle start open, and we ain't going to tolerate that kind of behavior on here. You come to make a living honestly, and, you know, like how all the rest of us do, we is not going to tolerate that. And please, you do something. Because one time I tell her about bam, bam, boom, boom, you know, taking people money up your tongue and running, going with it, you know, and you hear how she end up, I avoid it. I come on this very short GQ and talk about it. And a homicide commit. And if I will make a move, it couldn't happen. I will listen to people and let me get it right, because you say what you want about ASP Hanley, you know. You say what you want about my boy ASP Hanley. Oh my God. Inspector, former Commissioner Queeley, wherever you be, Bradford, I thank you for this forum. I thank you the devil and the Lord bring you to the circus. And you run it on me. Have a good day, guys.
Yes,
All right,
ma'am.
Jamdong. Thank you very much as usual.
Any response, or we take those two
No,
next on?
Take another call.
Line 2, you're live. Good morning. Hey.
Good morning, three officers at the most highest ranks.
Good
Good morning, culture. Good morning, culture.
Morning.
Okay, then, good morning. Yeah. I'm kind of confused with the definition of what is an assault. You know, earlier you spoke about, you drew an illustration of a guy passing on a bike and he point a gun at another man, but he didn't say nothing. And that isn't considered to be a threat.
No, it's not considered to be a threat. It's an assault.
Okay, yes, sorry.
Yes.
Well, a couple of years back, it was a Juvie morning on 4th Street. Some violent incident had just happened. And a member of parliament was standing on the sidewalk. And a young man, popularly known young man, come up and he said to the member of parliament, "You next." And the member of parliament went across the station and he reported it. And it ended. Nothing happened. And I think something like that should have been followed up and make sure that thing they come to justification. So what is the definition of assault? I will listen up here for the answer, please, for the sake of time.
All right, man.
Okay, three good men in there, boy.
It's where somebody apprehend immediate or personal violence. Yes,
That's
that
it?
is the definition of assault. And I gave the example. You know, okay, I could give another example. For example, you home and sitting on your veranda in a chair, and a relative of yours you know, y'all are not on good terms. And he comes out and he has a cricket bat, you know, and he makes an attempt to swing at your head with the cricket bat, but he did not swing the said cricket bat. And you apprehend immediate fear.
Of being struck with the bat.
Right, and that in itself is what considered an assault.
All right, let's go to the phone line. Good morning, line 3.
Yes, good morning, Officer GQ, and the other two official officers.
Good morning, buddy.
Good morning,
Yes,
sir.
officers first, you all ever consider when you're discussing issues like you're doing now, to get somebody from the court system who attached to the police force like a lawyer also?
That's why
Come
Sergeant.
and assist?
That's why Sergeant Richards is here this morning.
Eh?
That's why Sergeant Richards is here this morning.
Oh, he's a lawyer?
Well, he's attached to the court.
Okay, all right. Well, a lawyer's go always for them. Okay. My thing is, you see, education is so valuable. No matter what age you are, as long as you're alive, when you're properly informed and educated, it helps. But my question is, suppose someone goes into a business establishment and they snatch something, they thief it and they run, and they identify the person. But then they also identify that he gave this person gave it to somebody else who hold, you know, and then they also identify the person who has it. And then during the investigation, they found this thing with the person, whether at the home or what. They found them.
Bless you.
The one who they find with the goods, the stolen goods. Would they be charged? And if charged, what they be charged under? That's all.
Oh, yeah, go ahead. Which one you can
Well,
take
we're talking about several offences here, and as the inspector could confirm, you're talking about the stealing of the item or object or whatever it was, and the passing off of it to someone else, who either know it was stolen or stole it themselves. And that person ultimately will be charged for receiving what we call in law receiving stolen items. There's a doctrine, what in law is called the doctrine of guilty knowledge, which means that GQ should have either know it was stolen, or it would have stolen it, or you would have stole the item yourself. So therefore, you should have reasonably suspected that the item I gave to you was stolen, or you know it was stolen yourself. So you in turn, receiving the stolen items would be charged for receiving.
Okay.
And also, the person who steals it will be charged for larceny,
correct,
for stealing that item.
Okay. Line 1, good morning, you're live.
Yeah, hi, good morning.
Good morning.
Thank you.
Yes.
Richard and Bria.
Morning to you,
Morning,
sir.
sir.
Now, let us suppose we had a situation. I like how you spoke about investigating things thoroughly and meticulously whenever there is an incident. If I'm sitting in my vehicle and somebody took a piece of iron and they came across, they felt it and it damaged my vehicle, right? On the surface, it looks as if it's just damage to property.
Malicious damage.
Suppose where he left from, somebody could give evidence that he's going over there, go kill him, hit him one lick in the head with his iron, and kill him. But the way he threw the object, he wasn't that skillful. So he mashed the vehicle window instead of hitting me in my head and killing me. What would stop that person from being charged with attempted murder? You understand? That is one aspect. Now let us suppose somebody inflict grievous bodily harm to somebody, and they went to court and they got a 9-month sentence, and they spent 6 because it's the 2/3. But somewhere before a year and 1 day, even though the person would have come out of prison, somewhere between a year and 1 day, before a year and 1 day, the person died. Could you now go and rearrest that person and charge them again for causing death by whatever? You understand what I'm saying?
Yes, yes, sir.
Right. Could you do that before year and 1 day? Would that be considered in any light? Double jeopardy or anything like that? That's the question. Two questions.
Okay.
Why the person cannot be charged for attempted murder, especially if you get information from the person where he was standing beside and say, you guys know they're going to kill Natal with this piece of iron, one lick in his head, but he threw it in a kind of way that he damaged my property. Would he be charged for damaging property or even attempted murder? I will listen.
All right. That's going to be your final call. I'll let you respond to that, and then we'll wrap up.
Okay, well, to address the Mr. Natal, and I have nothing but respect for him. Him and I would have in the past had certain exchanges. To address the first incident of the damage to property. Now, facts are stubborn creatures, GQ, and we have a saying in law: facts can't change. Now, even though that individual who threw the steel or iron or whatever it was and damaged the property would have made those utterances somewhere else, decide, okay, I'm going to damage Mr. Natal and bust his head or whatever. The fact is,
said kill.
I'm going to kill him. The fact is, when he went to commit the act, he only damaged the vehicle. So therefore, within those facts, you could only charge him for the act he would have committed.
Even though the information was disclosed that his intent was to kill.
You have to look at the facts and the action.
Okay.
His actions caused damage to the vehicle. At the end of the day, there was no injury to Mr. Natal because they are what we call points to prove for certain offences. Okay, and the points to prove for attempted murder would not be covered in him damaging the vehicle, even though he would have said previously, I'm going over there to kill Mr. Natal. So at the end of the day, it is the actus reus, or the guilty action. Even though he had the criminal intent, his actions, the criminal act, does not constitute an attempted murder.
Okay.
So therefore, it would be difficult to charge him for an attempted murder.
So based on his awkwardness, he gets away.
Correct.
No, and just to
Sorry,
support,
I don't like
no,
moment.
no, and just to support what the good sergeant is saying, because by walking from point A to point B, you know, he might decide, boy, you know what,
May ain't gonna bother kill him.
and
Correct.
that is why he threw a piece of iron or steel and damaged the windscreen.
Okay.
So therefore, he has to be charged for the act that he committed.
Yes.
Secondly, to address the second situation, someone would have inflicted grievous bodily harm to Trevor Richards. Again, I use myself as the scapegoat.
Don't worry, I'm going to rebuke everything in the end.
And as a result of my injuries, GQ would have gotten 9 months in prison. However, the definition for murder includes the death occurring within a year and a day. So while GQ is serving the 9 months in prison, Trevor dies as a result of the injuries that GQ would have inflicted on him. Now, to charge GQ for murder, which wouldn't tantamount to double jeopardy because that is a separate offense.
Okay.
As a matter of fact, murder would be a great offense to inflicting grievous bodily harm.
Right.
Yes? You have to look at causation. Was Trevor's cause of death a result of the injuries that GQ inflicted? If yes, GQ can be charged for murder so long as the death has occurred within a year and a day. So yes, Mr. Natal, that is possible. Even though GQ would have gone to prison for the inflicting grievous bodily harm, that is a separate and distinct offense to the murder.
All right. Gentlemen, we're going to wrap it up here. I want to thank the callers for calling in and seeking clarification on their issues or concerns, if I could put it that way. And even though I'm not a pastor, I'm going to rebuke all those examples this morning.
Thank you very much, GQ.
Over to you, sir. Over to you.
Any closing remarks, Inspector?
Yeah, I know we coming up to the Christmas season, you know, and instead of offenses against the person, instead of wounding person, beating person, assaulting person, instead of using indecent language or threatening language towards other person. Let us inflict love or cause love, express love.
I hear you.
Share love.
I'm not in disagreement.
Share love. And the golden rule is do unto others as you would have them do unto you. And what the police is saying, is express love, share love, inflict love, cause love, instead of harm to other persons.
Thank you, Inspector Greer. Thank you for being here. Sergeant Richards?
Yes, GQ again, I do apologize for being late, but it was, for the time I've been here, it was a fabulous show as always. I want to thank the Inspector for coming, particularly to expound on the offences and offences against the person. GQ, I think we have a duty as police officers, law enforcement officers, to not just protect and serve, but to educate the ones that we protect and serve. Persons should be aware of what constitutes certain offences, what they can and cannot do within the confines of the law, and if they infringe those laws or regulations, so to speak, what the penalties are. So I want to thank the Inspector for coming here and shedding some light on those offences against the person. GQ, as always, it has been a pleasure. Thank you. I want to thank the listeners for listening. This has been another edition of Policing with You. Do tune in again next week. I've been your host for this week, Sergeant Trevor Richards.
About equal rights for all.